goodness, not too fast. Is it okay? I mean, I'm just really flying through this. Again, tomorrow, we'll do a complete review. We only have an hour from 8 to 9. Don't worry, we'll go through everything. Someone asked if they could record it. It's fine. That's cool. Yes. And here we go. We talked about vicarious liability. And there are different theories. The respondeat superior, let the superior reply, is the key. And notice, it's right there on the slide. If a physician's office nurse injects medication into a patient's gluteus maximus and in the process hits the sciatic nerve and causes the injury, the patient may sue the physician for the nurse's negligence. Now, some of this is changing to the extent that it's very possible the nurse may be part of the action as well, because nurses are gaining, in many ways, independent practice status of sorts as nurse practitioners. And so, again, in most jurisdictions, they still do it under the umbrella of a reviewing physician, and so the physician will be enjoined or the nurse may be enjoined in the action. Captain of the ship, borrowed servant, these theories are much older theories and primarily rely in the surgical suite. However, respondeat superior is what we're concerned about. Informed consent. Now, I'll go through this quickly. Informed consent has evolved over time. And I put these up here because I want you to know these cases. The three key cases that we want to know are Nathanson v. Klein, Canterbury v. Spence, and Truman v. Thomas. The Cruzan versus the director of the Missouri Department of Health, this went all the way up to the United States Supreme Court. That case was the case that stated the state of Missouri could require clear and convincing evidence to be the standard for the burden of proof in disengaging life support equipment. So please just remember, Cruzan, clear and convincing evidence. Okay, they both start with C's, clear and convincing, Cruzan. So you'll know that should that question appear on an exam. Nathanson v. Klein, Canterbury v. Spence, and Truman v. Thomas. What did these cases tell us? It was Nathanson v. Klein. This was the initial case that established this concept of informed consent. Nathanson v. Klein. Irma Nathanson goes to Dr. Klein. Unfortunately, she had breast cancer and a mastectomy was performed. And then Dr. Klein said, you know, I think it would be a good idea for me to do radiation therapy. And it was somewhat new in those days, and it wasn't as refined as it is today. However, Ms. Nathanson said, okay, and the radiation was just left scarring and burned the skin, and it was just a very disfiguring, uncomfortable result. And an action was brought against Dr. Klein. And Dr. Klein had said, well, you know, I thought it was reasonable to do this. And the court basically said, well, you know, was it reasonable? What would other physicians have said in this instance? And the real question was, did Ms. Nathanson give a real informed consent about this? Did she understand the real dangers? In fact, the doctor understood, did the patient? Well, the standard that was espoused by the court, and they based their decision upon the Schlowendorf case, 1914, and they said, and this was the landmark case, it was the first court requirement of informed consent, and that informed consent was the reasonable medical practitioner. Would a reasonable medical practitioner have engaged in this procedure? And would a reasonable medical practitioner have talked more with the patient? And they held that Dr. Klein, right, wrong, or indifferent, had not met that standard and he was held liable for it. This then moved to the Canterbury v. Spence case. I call this the Canterbury tale because this is about Jerry Canterbury who fell on his tail and was grossly injured. Jerry Canterbury was 19 years old and was a clerk for the FBI. And he was having radiculopathy due to compromise in his vertebral segments, and there was nerve impingement, and it was decided he went to Dr. Spence. Dr. Spence said, I think we need to do a laminectomy, and he said to Jerry, look, whatever you do, stay in bed after the surgery, don't get up, because we don't want you to slip and fall. And the mother asked, because at the time of this case, Jerry Canterbury, being 19 years old, was still held to be a minor, and so the mother asked, she gave the informed consent, and the mother asked, what are the potential risks? And Dr. Spence said, and I quote, no more dangerous than any other surgery. Now the patient claims later that he had not been informed, nor was the mother, that in 1% of these surgeries there is resulting paraplegia. Now interestingly enough, Jerry Canterbury has a surgery. He's doing brilliantly, I guess. I don't know, I wasn't there. He's doing okay. And instead of ringing the bell or the buzzer or whatever for a bedpan, gets out of bed to go to the bathroom after the surgery. Lo and behold, slips and falls, bam, winds up paraplegic and incontinent. So now you have this 19-year-old who's paraplegic and incontinent, and an action is brought. And he sues, claiming he didn't have the information to really know what was going on with this surgery. Now, he ends up paraplegic. In 1% of these surgeries, paraplegia can occur. However, it occurred because he slipped and fell. He slipped and fell because he got up and walked to the bathroom, and the doctor said, don't do that. Again, today, might there be a different result? There might be a different result today. However, the court said, and advanced the standard by saying, now there is a standard that is measured by the patient's need for information. And this now created the standard for materiality of information standard. And so what one has to explain based upon this is, what are the material potential risks of this intervention? And alas, Dr. Spence was held liable. Now, along comes Truman v. Thomas. And it may say in your handout, Clarence Thomas. It's not. He's a Supreme Court justice. It's Claude Thomas is the physician. Okay, Claude Thomas. So what happens, Truman v. Thomas. You have Ms. Truman, and Ms. Truman has been going to Dr. Thomas for years. And every year, Dr. Thomas asks Ms. Truman, what do you think? Shouldn't we perhaps do a pelvic and pap smear for you? And Ms. Thomas says, I'd rather not. Okay, so she doesn't. And this goes on every year until you guessed what happens. Now all of a sudden, she ends up with cancer, and ultimately she expires. And so now the family brings an action against Dr. Claude Thomas. So she deceased from the cervical cancer, and now what the court says, and they create the new standard under which we all practice, and that is, we have to advise patients of the risks and potential side effects of having a procedure, as well as the potential risks and side effects of not having the procedure. So we have to explain to patients, it is my recommendation that we do a pelvic and pap. If you choose not to have that done, then we may not know if there are underlying conditions that could put you at great risk for serious health decline and or death. And therefore, I recommend this be done. You have the right to refuse. I want you to understand the potential risks should you choose to refuse. And so that's important. When you all become interns, and you are in the position of doing physical exams, and you are put in the position of doing a rectal exam, you will have patients who will say to you, "Oh, doc, I don't think we want to go there." And it's important for you to be able to explain to the patient, it's important, this exam allows us to find if there are any lesions, space-occupying lesions or masses in the rectal vault, and in male patients, it allows us to note through tactile sense if there are any irregularities in that part of the prostate that we can feel via a rectal exam. Failure to have this exam could result in a tumor or some other issue going unresolved, and then getting to the point where we may not be able to intervene and treat. So it's important to explain to patients potential risks, side effects, and benefits of having a procedure performed, and the potential risks, side effects, and benefits of not having it done. Okay? And that is the stepwise progression. Started with Nathan v. Klein, and then the physician was held to be the reasonable medical practitioners. The responsibility was on the physician to be the reasonable informer, to be the individual to make this reasoned decision on behalf of our patients. And then Canterbury v. Spence moved it to, well, now the patient's going to make the decision, and the physician has to present the material information to the patient. Then Truman v. Thomas moved it to, not only do we have to give the patient information with regard to potential risks of engaging in the treatment, we also have to inform them of the risks if they choose not to engage in the treatment. And there is a subset of this as well. We may then be obligated to explain alternate treatment approaches also. To say to them, you know, this is the treatment that we're currently using. There are other options, and if you choose to follow those, while I may not be the individual best schooled in those options, you may want to look into them. Okay? And then we want to document and chart all of the above. The Cruzan case, I won't belabor it. This was the case where individual was in a serious motor vehicle accident. She then lay in a ditch without oxygen for 14 minutes until the EMTs could get there. And once they got there, they utilized all tools and techniques at their fingertips to reestablish heart rate and respirations, and she was in a vegetative state. The family had stated that they didn't think she wanted to have these types of procedures done to maintain her in a vegetative state, and the court said we don't have any documents to the contrary, and so we feel there has to be clear and convincing evidence. It ultimately went up the full Missouri State Court system to the Missouri State Supreme Court. With regard to clear and convincing evidence is the standard of proof, the burden of proof. It ultimately went to the U.S. Supreme Court. The U.S. Supreme Court was willing to review the clear and convincing evidence component, not willing to review whether or not the life support could be discontinued. And remember, clear and convincing evidence in this case. Remember to obtain informed consent. Who obtains the informed consent from the patient? Remember, this is up to you, the physician. You are the final frontier. It is up to you to obtain the informed consent. And once you obtain the informed consent, you must adhere to the scope of the consent. Remember battery. As it says there, as a general rule, a physician commits a battery if he or she exceeds the limits of the permission, the consent given by the patient. Informed consent exceptions. There are exceptions to the need for material disclosure. So, let's look at these four. What are the four exceptions to the rule? The four exceptions to the rule are therapeutic privilege, professional discretion, a competent patient who seeks not to know, common knowledge, and emergency situation. Let's look at these. Therapeutic privilege, professional discretion. This is wherein the I would recommend not invoking this, okay? This is where the physician feels that giving the information to the patient will traumatize the patient. And the patient will be so traumatized that just hearing this information will be so disruptive to the patient, it's worse to tell the patient about it than just to go ahead and intervene and treat. Now, this doesn't mean that you don't do it because you think the patient will refuse to take it. It means that you're really concerned that, that divulging the information could be harmful, dangerous, or injurious to the patient. Now, are there some patients who, when you give them information of potential side effects of a medication, they're just going to have every one of them? There are patients that happens. You know, it's just in med school. We read about a bunch of disease states, and all of a sudden we've got all these diseases. You know, it just happens, okay? And so there are some patients we may be a little more circumspect. However, if you feel that explaining potential risk side effects to the patient will be so traumatic that you feel it's prudent not to do it, then my recommendation is to ask the patient's permission to talk with family. And once you obtain that permission, to explain to family potential risks and side effects, as well as the benefits, and get their permission so that they know, and they know that you're concerned, and they know that you know, and they know what the potential risks are. And they will tell you, yes, that's good because my father, my mother, my aunt, my grandparent, just if you tell them about this, bless you, they'll go into a panic episode. So again, I'm very cautious about this. This used to be very common. Back in the 50s and 60s, the physician took on a very paternalistic or maternalistic perspective and said to the patient, don't worry about it, I'll take care of it. Now that's not the way it works. Now we tell the patients, these are the potential risk, side effects, and benefits. There is a therapeutic privilege, professional discretion. Please be very cautious, okay? Because if you don't give the information, something untoward happens, and the patient says, had I known that, I wouldn't have gone through with this. And you say, well, I was exercising therapeutic privilege, professional discretion. The patient says, no, you breached the obtaining of informed consent, man, and this is not cool. Okay. Competent patient who seeks not to know. Yes?
I just had a question. When I was on preceptorship, we had a woman come in who wanted an IUD placed.
Yes.
She didn't speak English, and there
Yes.
was no translator available
Yes.
or who spoke her language. So her daughter was young, probably 14 or 15. So how can you ensure informed consent if you don't know if the daughter has appropriate, like how can you know if it's informed consent if you don't know what the patient's actually hearing?
Okay. Then it's important to say to the daughter, now I want you to explain this to your mother, have your mother describe back to you what you just told me, and then you tell me what she said. Because as practitioners today, we're mandated to have a translator present, both for individuals who speak a different language and for individuals who are deaf. We are mandated to have someone who can sign and be competent. In fact, I actually saw a patient, did an independent medical exam for a patient, and had an interpreter for sign language present to perform that. Yes. The real key is if you can then get the information back, then you know whether or not the daughter was able to communicate age appropriately what that meant. Yes, yes. Competent patient who seeks not to know. This is the patient who says to you, Doc, I don't want to know. I don't want to know. I'm competent. I've never been adjudicated incompetent. I have the capacity to make decisions, and I've made the decision. Don't tell me. I don't want to know. Okay, in that kind of an instance, you document, you chart. After several attempts to explain to the patient potential risk, side effects, and benefits of this procedure, the patient was adamant in stating, I don't want to know, Doc, I don't want to know. Okay, and you put in quotation marks. If family members are present and if you can obtain permission from the patient to discuss this with family members, please do, because again, it's important that somebody knows that you know what the potential risks and side effects are and that you worry about them. Common knowledge. Whoa, Truman v. Thomas. Dr. Claude Thomas said to the court, everybody knows the importance of a pelvic and a PAP. Everybody knows the potential risk if you don't have it. So when I didn't tell, when Miss Truman said to me each time, Doc, don't do it, it's common knowledge. Now, be very careful. Don't rely on common knowledge because you might just end up with the patient for whom it isn't common knowledge. They don't know. So just assume your patient doesn't know potential risks, side effects, and benefits, explain them each time, and obtain informed consent. The emergency situation. Theoretically, no duty arises to inform in an emergency situation in which the patient is either unconscious or incapable of giving valid consent. Again, this is a balancing act. If the imminent harm and danger is outweighed by the potential risks of intervening, you intervene. Now, that being said, if there are family members there and you can say to them quickly while they're there, these are potential risks, this is an emergent situation, we really need to intervene, are you okay with this? Yeah, doc, go ahead and do it. You got family permission. If there's a durable power of attorney present, get the durable power of attorney's permission. If they have a DNR, do not resuscitate living will, go along with the DNR, do not resuscitate living will. Medical records. I have a long set of points here for medical records. Many of you will be moving into electronic medical records. What I'm writing about here is handwritten medical records. Electronic medical records are mandated, I believe, in 2014 for most practices. Small private practices may not have to go that route. However, standard practices who meet the criteria for HIPAA will have to go that route. Key thing to handwritten medical records, please write legibly. Not only write legibly, include data that's pertinent to the patient's care, avoid subjective editorial comments, be careful with abbreviations, include your thoughts on diagnosis and possible future paths for treatment, because you want an algorithm there so that others who are covering for you can look in your chart and go, okay, the doctor said if this medication is not effective or causes side effects, this is the next step we'll take. And if that's not effective, this was the next step. So that others covering for you have a reasonable perspective of where you're coming from and where you were hoping for the patient to go. Document communications with the patient, including and limited to informed consent for all treatment approaches. And this includes documenting phone calls after hours or even during hours. Please chart and document phone calls. Document the time. And when I say the time, the full time. When the conversation began, when it ended, put the date, put the patient's name, and put quotes in. I put mostly quote, what the patient says. And then I put down plan, and I write down what our plan is and what I express to the patient. Do not obliterate an error. In handwritten charts, don't tear off the bottom and tear it up. Don't take out a big black marker and go and mark it all out. No. The correct way to show an error or to change in the chart, in a handwritten chart, is to put one line through the lines that you are correcting, write error above it, put your initials, and put the date. And again, the reason this is important, and don't add stuff in later. Don't just go back, leaving yourself two lines on a page, and 2 days later go back and add stuff. Can you put an addendum in? You can put an addendum in. However, you date it and time it appropriately. Because today, forensic specialists are great at checking ink, and they can tell handwriting, and they can tell you darn near when that was put in there. So please, do not inappropriately mark in a chart. Do so with ethical and the best of intentions. Medical records. Statistics demonstrate that medical evidence is estimated to play a part in about 3/4 of all civil cases and 1/4 of all criminal cases brought to trial. What does that mean? A medical chart typically appears in 3/4 of all civil cases and 1/4 of all criminal cases. So remember, that medical chart is a legal document and it may show up in a public setting. So please, please, please be careful what you say in the chart. Now avoid editorial comments. Just put in the medical facts and issues. Okay? And again, I mentioned here, document phone conversations. An accurate narrative documentation written by the physician is the best way to document informed consent. I will say that again, at least at this point in time. An accurate narrative documentation written by the physician. What does that mean? That means that trumps a form that lists everything that could happen and the patient signs the bottom of it. A written narrative by the physician documenting what was done is still the best method of documenting informed consent. Again, I mentioned a medical chart appears in an evidentiary capacity in 3/4 of civil cases and 1/4 of criminal cases brought to trial. Correcting an error in the medical chart, again, one line through it, write the word error, date and initial the lined out error. Patient access to charts, we discussed this under the new Portability Act. Patients are entitled to review their charts in all 50 jurisdictions. Who owns the medical record? Who can have access to it? I know we discussed this. The medical practice owns the chart. The information contained in the record, the patient owns and has access to. Patient-physician relationship. Again, I'm doing my best to get through all this. Slide 67, we have 9 more slides. My goal is to get through them so we can do a visual demonstration that hasn't been done before. There has to be theoretically some physical contact, some nexus of contact. It can be created. It may be created by a single telephone conversation. Again, the magic words, I am not creating a patient-physician relationship via this telephone call. The courts tend to be very generous in assessing the creation of the patient-physician relationship. There's an old saying that equity abhors a vacuum. Well, that also means courts don't like to have patients just dangling out in the wind without a physician on the other end of the court. So they're very generous in implying or finding this patient-physician relationship. Courts will look to see if the patient had a reasonable expectation of treatment and/or did the physician undertake to render treatment. So again, they're generous in finding that nexus. Please, when there's a problem outside your scope of expertise, refer the patient out. Refer to a specialist and document that. Standard of care. This is the standard of care to which all of us as physicians are held, and I will read it aloud. To exercise the same degree of knowledge, skill, diligence, and care that any ordinary, competent physician would exercise under the same or similar circumstances. So that means we're held to the same standard of care as our colleagues. Again, the patient-physician relationship. Until that relationship is established, theoretically you are not legally compelled to treat strangers. Again, even during an emergency in most states. There are states now that have a duty to intervene. So check your state statute. Again, for so long as there's no patient-physician relationship, remember the 4 Ds, there's no duty. However, remember, detrimental reliance. If you make statements to the patient that the patient believes you are giving in good faith for them to act upon, they then, to their own detriment, may be relying on it. They may have an action in detrimental reliance. Medical malpractice insurance. When you're in practice, you'll want to have malpractice insurance. There are 2 types of malpractice insurance. There's occurrence policy, there's a claims made policy. Now, the occurrence policy includes incidents that occur during the policy period, regardless of when the claim is brought. So an occurrence policy means if you have a policy in 2012 and you perform treatment in 2012, the patient then brings an action against you in 2014. That action is based on the occurrence in 2012, and so your policy covers you even in 2014 because you had the policy when the action occurred. Does that make sense? A claims made policy covers you for when the claim is made. So if I have a policy in 2012 and something happened in 2010, and the patient brings the action now in 2012, and I have my policy in 2012, it's a claims-made policy. The claim is being made now, I'm covered. What's the advantage of one over the other? The advantage of one over the other is, let's say I buy an occurrence policy with a company, and I have that policy, and I carry that policy, and then I quit the policy in 2010. And then in 2014, an action is brought, and let's just say in that state, because the individual was under the age of 21, they may be able to bring the action until they are 21, and so they were 17 at the time, it's 4 years later, and now I say, wow, I had an occurrence policy, that occurred back when I had that policy, and now the company's bankrupt, it's out of business. Wow, I'm in trouble, because the company that covered me for that occurrence is no longer there. If I have instead a claims-made policy, and the claim is made now, the company I have now is solvent because I just paid my premium, they're still in business, I'm protected. So today, most physicians carry annual claims-made policies. Let's say you shift gears, and let's say you change practices and you change insurance policies, or let's say you have a broker that is keeps you apprised of the best price on a claims-made policy each year, and you switch companies. Now what do? What is important for you to do? The claims-made policy that you purchased this year, they're going to ask you to get a reporting endorsement for your policy, and what that means, it's called a tail, and it's called covering your tail. And what that means is they want to be sure that actions brought from years past when they weren't your insurer, that they've got a little extra money in the bank to cover that for you. So they're going to ask you to pay for a reporting endorsement. And so that means is it's going to cost you extra. It's a rider to your policy that covers all prior potential actions arising from possible claims that may have arisen prior to your current insurance policy. It's the same thing when you retire. When you retire, you purchase your tail so that you're still covered for 4 years out. Does that make sense? So you have claims made. That covers you for any claims that are brought up in that year. An occurrence policy covers you for anything that occurred in that year. You have to pray that that company stays in business. Okay? And the reporting endorsement covers you for everything that went behind you. Does that make sense? Okay.
Is there a standard statute of limitations for how long people can?
Statute of limitations, and I'm glad you asked. It varies from state to state. However, the usual and customary approach is patients have essentially 2 years, and I'm relying on the Illinois statute, 2 years within which to bring a malpractice action. However, it may be up to 4 years if they didn't discover it in the initial 2 years. And if they are under 21 at the time, theoretically then they have until they're 21 to bring the action, yet states will limit how long that is. Okay, does that make sense? So those of you who choose to do OBGYN and you're doing deliveries, theoretically, individuals will have until they're 21 to bring an action if they feel that the injury was due and resulting from the delivery. So that's why the insurance policies are so expensive, because they're covering a much broader, longer period of time. HIPAA, I'm not going to cover that because I believe you all are familiar with that. The key is sign-in sheets are okay, calling patients to remind them for their appointments, okay, leaving messages on an answering machine, okay, for so long as we don't include the diagnosis. You can't say, this is Dr. G's office calling for you to come in for your appointment on Monday to treat that nasty XYZ disease that you have. You can't do that. You can't say, this is Dr. G's office reminding you that we have an appointment tomorrow at 10 o'clock in the morning. That way, if someone else listens to the answer machine, they can say to the person, oh yeah, I got a call from a doctor's office, they say you have an appointment. What's going on with that? And they can say, I choose not to waive my right to confidentiality, so I'm not going to tell you. I'm keeping my privilege intact. And release of information is allowed with patient consent to their insurance company for treatment, payment, healthcare operations. And patients do that. When they obtain insurance, they're signing on the dotted line. Courtroom testimony. There are two types of witnesses in the courtroom. The two types of witnesses are a fact witness, or called a percipient witness. These are individuals who simply state and relate direct observations. They saw what happened, they heard what happened, they just come in and give you the facts. Then there are expert witnesses. Expert witnesses are the only witnesses in the courtroom who will render an opinion. Expert witnesses. Expert witnesses are held to a standard of being well-versed in whatever it is they're discussing, and it's typically related to science or some profession that is beyond the scope of the typical layman or woman. And so these individuals are allowed to give an opinion. Now, what happens, in order to be an expert witness, your attorney, the attorney who's bringing you in to testify, is going to engage in what's called qualifying you. They're going to qualify you. What does that mean? Qualify you as an expert witness. They're going to ask you a series of questions that establish the fact that you are trained in that area into which you're going to give an opinion. So they're going to ask you the following things. They'll ask, could you please tell us your name? Could you please tell us in which city you live? Can you please tell us what it is that you do? Yes, I am a physician. Can you please tell us where you attended medical school? Yes, I attended Andrew Taylor Still University, Cruzan College of Osteopathic Medicine. Will you please tell us where you did your internship? Will you please share with the court where you did residency, fellowship, and would you please share with the court if you are board certified, and on and on. One of the performances in the qualifying is to make your expert look brilliant. And because of that, oftentimes opposing counsel will participate in what's called stipulation. They will stipulate. They will get up and say, Your Honor, we stipulate that the witness is an expert witness, period. Because they don't want the jury to hear that you attended the Harvard of osteopathic medical training, Andrew Taylor Still University, Cruzan College of Osteopathic Medicine. They don't want you to give them your stellar record. They don't want you to tell the jury your publications and all of the great things you've done. So instead, they'll get up and say, we stipulate.